The country woke up to a shock that seemed impossible until it arrived. No strategist, no insider, and certainly not the person at the center ever believed this moment would come. A legal earthquake hit with a force that erased years of stalling tactics, political posturing, and the assumption that power can shield those who once held it. For the first time in modern history, the highest court issued a ruling so brief, so precise, and so absolute that it ended decades of perceived legal immunity for the former president. Two simple words accomplished what countless hearings, motions, and arguments never could. Petition denied. Those words shattered the legal pause that had been stretched, twisted, and manipulated for years, finally moving the clock forward and leaving the former leader staring at consequences he thought could never reach him. For years, his approach had been methodical. Delay, appeal, repeat. Extend every case until time itself became his shield. That shield vanished the moment the ruling was announced. Overnight, the walls he depended on collapsed in silence. He awoke believing months, maybe a year, remained before the law could touch him, only to realize by evening that the final barrier between him and accountability had been obliterated. The shock within his inner circle has been described as absolute, almost apocalyptic. Attorneys who once promised endless lifelines now have nothing left to file, nothing to request, nothing to stall. The road ends here. The ruling's impact wasn't just in its verdict, it was the speed, the finality, and the message it sent. No former leader, regardless of power or prestige, stands above the law. The appeals court had made it clear years earlier, once out of office, you return to citizen status, and citizens must face the consequences of criminal acts. By refusing to hear the appeal, the High Court reinforced that principle decisively. Legal analysts were stunned not only by the rejection, but by the immediate activation of the lower court's order. There was no procedural buffer, no breathing room, no delay. The moment the ruling dropped, the machinery of justice roared back to life. Investigators could act, prosecutors regained authority, judges reclaimed jurisdiction, and stalled cases accelerated instantly. The special prosecutor now has an unobstructed path to move the federal charges into trial, and the judge overseeing critical proceedings can resume scheduling and sentencing without delay. Inside the former president's residence, sources describe a state of disorientation and panic. He had long treated the highest court as a sanctuary, convinced its conservative majority would protect him. Discovering they would not intervene left him stunned. Close associates report he repeatedly questioned why justices he had appointed would abandon him, seemingly prioritizing institutional integrity over personal loyalty. That realization hit harder than any election loss or courtroom defeat. Arguments erupted behind closed doors, with him blaming attorneys for failing to craft the right defense. Yet constitutional scholars agree, no argument could justify blanket immunity for a former leader facing criminal allegations. The law would not bend, and the court refused to compromise its credibility to shield an untouchable class of officials. This ruling doesn't just speed up the criminal process, it detonates political and financial consequences that his circle is scrambling to manage. His political operation had raised staggering sums, promising supporters that the appeals process would save him. Now, with the final appeal gone, those promises collapse. How do you convince donors to fund a defense that no longer exists? Already, major financiers are quietly stepping back, realizing this battle is effectively unwinnable. Fundraising messages must shift from confident resistance to desperate survival, a near impossible task for a movement built on the illusion of invincibility. The financial strain is immediate and severe. Without the delays that stretched out legal bills, costs will crash down all at once. The campaign, already carrying significant debt, faces a fiscal crisis that cannot be spun, postponed, or blamed on rivals. This is not political theater. This is law, and law demands payment. Meanwhile, the political consequences are just starting to unfold. Lawmakers who once evaded questions about his legal exposure by saying, "Let the appeals process play out," now face an unavoidable reality. The process has fully concluded. Every senator, representative, and candidate must confront a single pressing question. Do they stand with the justice system or with someone now on track for criminal trial? Reporters following legislators note a tangible tension. Some avert eye contact, others walk away silently. Conservative commentators who once defended him are now acknowledging an undeniable reality. One prominent analyst remarked, "The story is over, not because of politics, but because the highest judicial authority in the land has ended the debate." Claims of political persecution collapse instantly when the institution, long respected by conservatives, refuses to entertain them. The case now returns to the federal judge, who has emphasized that the public deserves a swift resolution. Her courtroom, known for efficiency and discipline, can now set immediate timelines. Experts predict a scheduling hearing could occur within days. The trial date, paused during the appeal, will return to the calendar, likely landing in the heart of campaign season. The implications are striking. The former president may spend peak election season in a courtroom instead of at rallies. The symbolism is undeniable. A national candidate seated at the defense table while prosecutors present evidence of attempts to overturn an election is politically devastating. The ruling also removes the last barrier, preventing key witnesses from testifying. Executive privilege claims can no longer shield former aides from describing private conversations, instructions, and decisions. Individuals who once remained silent out of loyalty or fear now face legal obligations to testify truthfully. And truth is exactly what the former president fears most. Observers note his psychological state is deteriorating. He has spent a lifetime believing every crisis could be negotiated away. Lawsuits, bankruptcies, scandals, controversies, they all had exit strategies, settlements, or appeals. This time, there is no exit, no bargain, no escape. The realization has left him swinging between anger and quiet despair. He repeatedly questions why the system he once thought he controlled is now turned against him, insisting there must be another option when none exists. Staff members report heightened anxiety, noting pacing, long stares at documents, and attempts to will outcomes into existence. Even loyal aides admit they've never witnessed him like this. The defeat isn't just external. It strikes at the very core of his identity. As federal proceedings resume, prosecutors are ready to present the full scope of evidence. Thousands of documents, recordings, communications, and sworn statements. The defense's central argument that a former president cannot be prosecuted for official actions is now invalid. The strategy that remains is incoherent, leaving the legal timeline relentless. Once jury selection begins, media attention will focus sharply on every detail, witness, transcript, and exhibit. Supporters who once believed in his immunity will now see him judged as any other citizen. Opponents will witness a moment they never expected, a former commander-in-chief facing criminal charges without any remaining legal shield. Panic is spreading within political circles. Party leaders who relied on ambiguity now have no cover. The court's silence has removed the protective pause. Some will distance themselves, others will double down, but all will be forced to act. The most profound aspect isn't just that he faces trial, it's that the justice system proves stronger than any individual. Power, no matter how vast, cannot rewrite accountability. This precedent will echo through generations. The presidency does not confer permanent immunity. Inside Washington, the ruling has triggered emergency meetings across political committees, think tanks, and donor networks. Strategists are recalibrating, realizing that the candidate they built their entire election strategy around could now spend months trapped in a courtroom. This is an unprecedented scenario, one no party has ever faced. The coming weeks will be defined by rapid legal motions, witness disputes, media storms, and political fallout. Yet the central fact remains unshakable. The highest court has spoken. The appeals are over, and the former president is teetering on the edge of a legal abyss he cannot ignore, delay, or escape. The nation is watching closely. Supporters are stunned, critics vindicated, neutrals shocked, and the former leader, once insulated by layers of legal protection, now stands exposed, facing a future he never imagined. No one anticipated this stage of the crisis would arrive so quickly or with such raw intensity. The country hasn't even digested the shock of the last ruling, and the fallout accelerates, pulling every political corner into a storm beyond control. Inside his circle, whispers warn that this may be the moment he becomes more dangerous than ever. A cornered figure with nothing to lose rarely retreats quietly. Advisors describe him pacing, shouting, and venting online in increasingly volatile bursts. Security officials are already concerned that his online platforms could become stages for a spiraling meltdown, outbursts, attacks on judges, prosecutors, investigators, statements designed to provoke anger, and perhaps even calls to unrest among his most loyal supporters. Law enforcement treats this as a serious possibility, not a theoretical one. Federal marshals are preparing, protective details are reinforced, and every precaution is being taken. The system understands the psychology of a figure whose power is slipping. A wounded political leader, particularly one addicted to adoration, becomes unpredictable, and unpredictability is exactly what authorities fear. The shock isn't confined to domestic observers. The international community is watching closely. Allies and adversaries recognize that the US justice system has demonstrated a willingness to hold former leaders accountable. It sends a clear message. The rule of law operates even at the highest levels. But it also signals a troubling reality. A major national candidate is entangled in a criminal case that could last months, overshadowing diplomacy, dividing institutions, and damaging the country's image abroad. Foreign governments are on alert, monitoring developments that may reshape global power dynamics. With the final appeal denied, the stakes are staggering. The charges conspiracy against the government and obstruction of an official procedure carry potential decades-long sentences. Judges weigh multiple factors: the gravity of the offense, lack of remorse, repeated public attacks on the judicial system. These often result in substantial prison time. There are no alternatives, no home confinement, no privileged arrangements, no luxurious retreats. Federal agents and protective services are already planning how to secure a former head of state within a federal penitentiary, a conversation that alone illustrates the crisis's severity. This is the reality unleashed by the court's ruling. Media outlets are scrambling to catch up, revising scripts, graphics, and live coverage. For months, analysts claimed the case would be delayed until after the election. They were wrong. The highest court acted swiftly, decisively, and without hesitation. Suddenly, every newsroom is asking the same question: not if, but when will a verdict come? This shifts everything: polling, fundraising calculations, campaign strategy, potential running mates. Who would join a candidate potentially sentenced before election day? Commentators who long claimed deep state conspiracies are struggling to maintain their narrative. For years, they argued every investigation was part of a grand plot. But that collapses when the court they once praised, dominated by conservative appointees, rejects the former president's last line of defense. If the system were truly rigged, why would judges known for strict constitutional interpretation refuse immunity? The conspiracy theory implodes under its own contradictions. Meanwhile, the former president is expected to lash out at his legal team. Firing attorneys under pressure is his signature move. He may file futile motions, attempt procedural stalling, or even threaten to boycott the trial entirely. But the presiding judge is known for unwavering discipline. She can compel his presence, issue warrants, and enforce court standards. The image of federal agents escorting a former leader to court grows increasingly plausible. The High Court's message is unmistakable. The legal process is no longer paused. Responsibility now rests fully with the trial judge. Silence from other party candidates is notable. Their campaigns were built on waiting for court decisions to buy time. That time is gone. The possibility of a fractured party convention is rising. Advisors are already debating whether to nominate someone else if the former president spends the general election sitting at a defense table. Imagine the alternative campaign slogan: choose the candidate who won't end up behind bars. Harsh, but effective. Behind closed doors, party strategists are in panic mode, aware that nominating someone facing potential sentencing mid-campaign could trigger chaos. Delegates might revolt, factions could split, and conflicts could erupt on the convention floor. This isn't merely a political problem, it's an organizational crisis. And then there's the financial pressure. Legal expenses for a criminal trial are astronomical. Investigators, expert witnesses, travel costs, lodging, consultants, and research burn through resources at a staggering pace. Civil cases already drain millions, but criminal cases consume far more. With delays removed, the burn rate skyrockets. Major donors are quietly stepping back, unwilling to fund a defense that appears doomed. Even the National Political Committee has hinted it will not cover criminal legal bills, leaving the former president facing a liquidity crunch, precisely when resources are most critical. Financial pressure compounds legal pressure. Consider the jury. The trial will take place in the nation's capital, a jurisdiction where he is deeply unpopular. He had fought hard to move the case elsewhere, but with the appeal denied, the venue is locked. The jury will be drawn from the very population where the alleged offense occurred. He believes this guarantees bias and will protest loudly. But the law is clear. Trials occur where actions took place. The symbolism is stark. The city whose democratic process he attempted to overturn will now determine his fate. The ramifications extend far beyond the courtroom. This ruling impacts every corner of national politics. It stabilizes institutions by proving that no leader is above the law, but it also propels the country into an unpredictable election year. The upcoming election is no longer just a battle of policies, it becomes a referendum on the rule of law. The former president will position himself as a persecuted outsider, while the current administration frames itself as the guardian of constitutional order. Whether intentional or not, the judicial system has set the stage for a dramatic clash, and the nation must navigate what is arguably the most unstable election cycle since the Civil War era. Ordinary citizens, many unaware of daily legal updates, will wake up to headlines stating, "Supreme Court rejects former president's final appeal." Those words carry finality, cutting through misinformation and signaling a simple truth. The system has spoken, and not in his favor. In a political movement built on invincibility, once the myth of untouchability evaporates, support begins to crumble. Credibility, the currency of a strong man, collapses alongside the illusion of protection. The ruling achieves another critical effect: it revitalizes public confidence in the judiciary. The High Court, long criticized and distrusted, could have reinforced the notion that powerful individuals play by different rules. Instead, by refusing to intervene, it affirmed that loyalty lies with the Constitution, not any political figure. The institution preserved its legitimacy and may have restored trust among citizens who feared the judiciary had been compromised. The landscape is clear. The final avenue of escape is closed. The former president stands without delay, without protection, without excuses. The shield he relied on for decades is shattered. Evidence will be presented, witnesses will testify, and the trial will proceed without obstruction. The system has finally caught up to the man who believed he could outrun it forever. This is the moment when truth steps into the light. In the weeks ahead, there will be noise, outrage, and chaos. But beneath it all, one fact remains unmovable: the law governs everyone. For the first time, that truth is being tested at the highest level, and the nation is watching closely. History is unfolding in real time. Supporters are stunned, critics vindicated, and those who were neutral are shocked. The former president, once surrounded by layers of legal insulation, now stands alone, facing a future he never imagined. The speed and intensity of this next stage of the crisis have caught everyone off guard. The shock of the last ruling has barely settled, yet the political and legal fallout continues to accelerate, dragging the entire system into turmoil beyond control. Inside his circle, advisors warn that this may be the moment he becomes more dangerous than ever. A cornered figure with nothing left to lose rarely retreats quietly. Observers describe pacing, shouting, and increasingly volatile online activity. Security officials fear his platform could be used for spiraling outbursts, attacks on judges, prosecutors, investigators, and statements designed to provoke anger or even incite unrest among loyal supporters. Law enforcement takes this seriously, reinforcing protective details and preparing for any scenario. The psychology of someone watching his power slip away is well understood. A wounded leader addicted to adoration becomes unpredictable, and unpredictability is what authorities fear most. The international reaction has been immediate. Allies and adversaries alike are closely monitoring developments, recognizing that the US legal system has shown it can hold former leaders accountable. This demonstrates that the rule of law operates at the highest levels, but also signals a troubling reality. A major candidate is entangled in a criminal case that could last months, overshadowing diplomacy, dividing institutions, and weakening the country's global standing. Foreign governments are alert, tracking developments that could shift power dynamics worldwide. The legal threat is now clear. With the final appeal rejected, the potential consequences, if convicted, are severe. Charges of conspiracy and obstruction carry decades-long sentences. Judges weigh the seriousness of offenses, lack of remorse, and repeated public attacks on the judiciary, all factors pointing to substantial prison time. There is no home confinement, no luxurious arrangements, no exceptions. Federal agents and protective services are already planning security for a former head of state in a federal penitentiary, illustrating how far this crisis has progressed. Media outlets are scrambling to keep pace, rewriting narratives and graphics as analysts' predictions about election delays collapse. Suddenly, the question is not if a trial will occur, but when. This reshapes every element of politics: polling, fundraising, campaign strategy, and decisions of potential running mates. Shadowy deep state narratives are collapsing as well. Claims of conspiracies crumble under the weight of a court dominated by conservative appointees rejecting the former president's final defense. Within his own circle, he may lash out at his legal team, firing lawyers, filing pointless motions, or attempting procedural delays. Yet the presiding judge can compel his appearance, issue warrants, and enforce court standards. The possibility of federal agents escorting a former leader to court becomes real. The message from the High Court is clear. The legal pause is over, and responsibility now falls entirely on the trial judge. Silence from other candidates is telling. Their campaigns, once waiting on court decisions for cover, now face exposure. This could create a fractured convention, delegate revolts, and internal party conflict. Financial pressure compounds the legal challenge, with legal bills burning through resources at a previously unimaginable rate. The jury will be drawn from the very city where the alleged offenses occurred, guaranteeing symbolic resonance. The ruling affects every political corner. It stabilizes institutions, proves no leader is untouchable, and plunges the country into an unpredictable election cycle where the rule of law itself becomes a central issue. The former president will frame himself as a persecuted outsider, the current administration as the guardian of constitutional order, and the judiciary has set the stage for a historic clash. The final avenue of escape has closed. Evidence will be presented, witnesses will testify, and the trial will proceed. The system has caught up with a man who believed he could outrun it forever. The truth is stepping into the light, and the nation must watch as history unfolds.